Bloomberg Audio Studios.
Podcasts, radio, news.
Welcome to Bloomberg UK Politics, your bite-sized guide to the corridors of power. I'm Yuan.
And I'm Stephen Carroll. Welcome to the show. Today, a shipwreck, a hedge fund manager, and the South African government. What do they all have in common? It might sound like a bit of a complex riddle or a bad joke, depending on your point of view, but they're all the protagonists of a fascinating story we're going to tell you about on today's podcast. So, South Africa has been locked in legal battle with the investment firm Argentum over silver salvaged from the Indian Ocean. The SS Tilawa was heading for Durban originally, hence the South African claim, and it was torpedoed by a Japanese submarine in 1942 with a sizable amount of silver on board.
Well, most people thought the silver was lost forever until Argentum completed an expedition recovering £37 million worth of it. Despite a degree of back and forth in the courts with South Africa appealing an early decision to award the silver to the company, today the Supreme Court have ultimately ruled in South Africa's favour. The eventual conclusion was based around the principle of state immunity, meaning that South Africa doesn't have to submit to a lawsuit at all. The two sides also come to a settlement over Argentum's salvage fee for recovering the metal.
So we have a conclusion, but questions still remain. Prior to the decision, many legal critics were warning about the consequences of a ruling against state immunity, which has been upheld here. Then there's the question of the British financier Paul Marshall, whose hedge fund backed the expedition. He recovered the silver at great expense. Will he have walked away with a fair share? And what does the ruling mean for future deep-sea salvage missions?
Well, let's start with an overview of the case with Bloomberg editor Olivia Solon. Now, Olivia, what was Paul Marshall's argument in this case?
Very basically, the argument was that his company Argentum had found the silver, they'd invested all the money in going to bring it up to the surface, and as such, under British law, they were entitled to a share of the proceeds, a so-called salvage fee.
Now, the judges had ruled in favour of Paul Marshall's hedge fund and against South Africa in two lower courts. What was their reasoning in those decisions?
Well, in order for the award to be granted to Argentum, they needed to argue that the silver that was in transit was in commercial use. And this was a private ship, and the silver itself has not yet reached South Africa, where it was going to be used to be melted down and turned into coins. The South African government, on the other hand, argued that it was intended for government use and therefore ultimately was subject to state immunity. And so they did not need to be subject to this case.
So what does this mean? This is a subject, Olivia, that I know that you've been writing about for some time. What does it mean for companies like Argentum and the future of deep sea exploration for this kind of treasure?
Well, the world of deep sea treasure hunting is a massive wild west, and there's constantly disputes over ownership that get more and more complicated depending on where the ship sunk or how old the ship was and who owned it at the time. So I guess it means that treasure hunting companies just need to be very careful about their shipwreck targets. Although often when they find stuff on the seafloor, it takes quite a lot of work to determine what the ship, whose ship it was, and then the disputes follow after that.
How expensive a process is it? It sounds to me like it would be enormously expensive. I guess there's a lot of wealthy firms and wealthy people doing these adventures, if you like. But how expensive is it to find these ships?
Treasure hunting, specifically deep sea treasure hunting, is a very expensive business. I mean, the technology has improved immensely lately, so suddenly we're able to uncover large swathes of the seafloor that hadn't really been visible before, thanks to robots and submarines that all work together scanning the seafloor. But it's expensive work. The fuel's expensive. You need huge fleets of autonomous and crewed ships to scan the floor and then lift things up from what can be miles down below the sea surface.
Yeah, it really is incredible what they're able to achieve. Olivia Solon, Bloomberg editor, thank you very much for joining us with the details of that decision. Now, in advance of the decision, there were these warnings in the legal world about the consequences that it could have on the UK's reputation as a place to do business. And one of the legal experts who has talked about this case in the past and joins us now to discuss further is Robert Volterra, who is a partner at the law firm Volterra Fietta and an expert in this area of law. Robert Volterra, welcome to the programme. Great to have you with us. What's your view of today's Supreme Court decision?
Thank you for inviting me to join you. This decision will be welcomed by mainstream public international lawyers and by governments around the world. In the last 5 or 10 years, the English courts had been stepping away from what we would call orthodox public international law related to state immunity, and they had been eroding um, traditional state immunity, which is extremely important to international law, and the International Court of Justice has recognized repeatedly as a foundation of the rule of law internationally. And the English courts had been in dangerous circumstances, um, reading down traditional Orthodox state immunity, particularly around exceptions for commercial, quasi-commercial activity in ways that were alarming governments around the world. Our clients around the world were responding.
Just taking a step back, explain the principle for us. Why should a foreign government like South Africa be immune from prosecution? Why should they have state immunity?
Well, that's a great question. And it revolves around the idea entrenched in the UN Charter, Article 2, that all states are equal, whether it's big, important, wealthy country like the United Kingdom or a smaller, less developed country. All states are equal in international law. And that means that no state can subject another state to its internal laws and courts and rulings without without the agreement of that other state. That's a basic principle of international law and international relations, and it stops big countries bullying smaller countries. It stops violations of what we call the rule of law between countries. And it's very practical because it means that countries can send diplomats to each other's territory to engage in discussions, negotiations, carry out the peaceful management of relationships between countries without worrying about arrest for non-compliance with local laws and things like that. So, for example, in this particular case, one of the arguments raised by the company was that they have a right under the European Convention of Human Rights, Article 6, to access to courts. And the Supreme Court here in this judgment today confirmed that that right, to which the UK signed up when it signed up to the European Convention on Human Rights, is not does not mean that state immunity is always trumped, and that the court decided that the UK Parliament intended that general human right under the Human Rights Convention to be subject to state immunity, with some exceptions, but basically it wasn't a way to avoid uh, according state immunity to other states, because South Africa, for example, did not sign up to the European Convention on Human Rights, and so it would be entirely improper for the UK to impose the UK's obligations under the Convention on Human Rights on a country like South Africa that hasn't signed up to it.
Okay, so it's this question of sort of which hierarchy of norms is more important between that idea of state immunity and the arguments being made under the Convention on Human Rights. There were fears in advance of this ruling that a ruling against South Africa might have hurt the UK's reputation internationally. Why?
Really important question, because there's been a series of judgments, including a very controversial decision a couple of years ago from the UK Supreme Court in a case called Basfar and Wong, that essentially people that wanted to make claims against countries in the English courts were finding that if they just made reference to commercial law, employment law, some human rights law, that the English courts were dismissing sovereign immunity claims by states and reading into, in very tortuous ways, um, things like domestic English employment law, domestic English commercial law, and the exceptions to sovereign immunity that do legitimately exist revolving around commercial activities of states. The English courts were eroding significantly the protections of diplomatic and state immunity. And other states were reacting. We have a number of clients. We act for governments around the world, including the UK, on various public international issues. And we know we have clients around the world, governments, looking at what was happening in the UK and saying, wow, if the English courts are not going to give us sovereign immunity, we don't have to give reciprocity to UK diplomats or the United Kingdom. And they've begun drafting sort of specific reciprocity or mirroring amendments to their state immunity legislation in response to the English courts, and basically saying, not saying it in so many words, but essentially saying if a country doesn't give us state immunity and diplomatic immunity in their courts, we don't have to give it to them in our courts. And then you'll get a very significant breakdown in how countries can deal with each other. I mean, think of British diplomats in challenging situations overseas. Iran, for example. And imagine if Iran was able to deal with British diplomats, not under diplomatic and state immunity, but by saying, well, you have to comply with all our domestic laws, and you're not because of X, Y, and Z, so we'll strip you of your immunities. That I'm sure the UK public would not be happy with that.
Robert, just briefly, it's something that you think that Parliament should tackle in the UK. Or are you happy for this to be left in the hands of the courts?
This ruling today is a very welcome indication that the UK Supreme Court is noting the trend of the English courts to move away from the orthodox protection of state immunity, and is perhaps giving some corrective measures, corrective directions to the lower courts. Ultimately, this would be something that probably will be safest in the hands of Parliament to address it clearly, and to reconfirm state immunity and reconfirm what is properly exceptions to state immunity, rather than allowing for some of the drift of the courts that's been happening recently.
Okay, Robert Volterra, great to get your point of view. Partner there at the law firm Volterra Fietta, an expert on public international law. Appreciate getting your opinions on this very interesting court decision from the Supreme Court. That's it from us for today. If you like the programme, don't forget to subscribe, give it 5 stars so other people can find it on Apple Podcasts, Spotify, or wherever you listen.
This episode was produced by Tiwa Adebayo and James Walcock, and our audio engineer was Sean Gostamakia. I'm Yuan Potts.
And I'm Stephen Carroll. We'll be back with more tomorrow. This is Bloomberg.
Bloomberg UK Politics. Listen weekdays at noon on DAB Digital Radio in London.